Day, future lawyers, and we're back with a new video on obligations and contracts. Under Article 1156 of the new Civil Code, an obligation is a juridical necessity to give, to do, or not to do. There are four essential requisites of an obligation. 1. A juridical or legal tie which binds the parties to the obligation and which may arise either from bilateral or unilateral acts of persons. 2. An active subject known as the obligee or creditor who can demand the fulfillment of the obligation. 3. The passive subject known as the debtor or obligor from whom the obligation is juridically demandable. And 4. The fact, prestation, or service which constitutes the object of the obligation. The vinculum juris or juridical or legal tie, efficient cause, that which binds or connects the parties to the obligation. It is established by 1. Law, 2. Bilateral acts, by contracts giving rise to the obligations stipulated therein, and 3. Unilateral acts such as crimes and quasi-delicts. The sources of obligations are law, contracts, quasi-contracts, acts or omissions punished by law, and quasi-delicts. Example of obligation arising from law. Article 2014 of the new Civil Code, which provides no action can be maintained by the winner for the collection of what he has won in a game of chance, but any loser in a game of chance may recover his loss from the winner with legal interest from the time he paid the amount lost and subsidiarily from the operator or manager of the gambling house. Hence, the loser may recover the loss from the winner with legal interest from the time he paid the amount lost. Second example is Article 291, the obligation of the spouses to support each other. Obligations of employers under the Workmen's Compensation Act, and obligations of the owners of the dominant and servient estates in legal easements. Obligations arising from contracts. In obligations arising from contracts, the obligation to deliver arises from the moment of the performance of the contract unless there is a stipulation to the contrary. Before the delivery of the things and the fruits thereof, the creditor merely has a personal right against the debtor, which is the right to demand the delivery of the thing and its fruits. Upon delivery of the thing and its fruits, the creditor acquires a real right over the thing and its fruits, which is enforceable against the whole world. Now, what are quasi-contracts? Under Article 2142, certain lawful, voluntary, and unilateral acts give rise to the juridical relation of quasi-contract to the end that no one shall be unjustly enriched or benefited at the expense of another. An example of a quasi-contract is negotiorum gesture under Article 2144. Whoever voluntarily takes charge of the agency or management of the business or property of another without any power from the latter is obliged to continue the same until the termination of the affair and its incidents, or to require the person concerned to substitute him if the owner is in a position to do so. This juridical relation does not arise in either of these instances. 1. When the property or business is not neglected or abandoned. 2. If in fact the manager has been tacitly authorized by the owner. Another example is solutio indebiti. Under Article 2154, if something is received when there is no right to demand it and it was unduly delivered through mistake, the obligation to return it arises. Another source of obligation is quasi-delicts. Article 2176. Whoever by act or omission causes damage to another, there being fault or negligence, is obliged to pay for the damage done. Such fault or negligence, if there is no pre-existing contractual relation between the parties, is called a quasi-delict and is governed by the provisions of this chapter. Question: are obligations transmissible? The general rule is found in Article 1178. Subject to the laws, all rights acquired in virtue of an obligation are transmissible if there has been no stipulation to the contrary. Contracts take effect only between the parties, their assigns, and heirs. Exception: nature of obligation, law, or stipulation to the contrary provides otherwise. As a general rule, the death of either the creditor or the debtor does not extinguish the obligation. Obligations are transmissible to the heirs except when the transmission is prevented by law, the stipulations of the parties, or the nature of the obligation. Only obligations that are personal or identified with the persons themselves are extinguished by death. Breaches of obligations. Article 1170. Those who, in the performance of their obligations, are guilty of fraud, negligence, or delay, and those who in any manner contravene the tenor thereof are liable for damages. A. Fraud or dolo. The fraud contemplated by the foregoing provision is the deliberate and intentional evasion of the normal fulfillment of obligations. B. Negligence or culpa. Fault or negligence of the debtor as an incident in the fulfillment of an existing obligation. C. Delay or mora. Delay in the fulfillment of the obligation. The delay, however, must be imputable to the debtor or obligor. And D. Those who in any manner contravene the tenor thereof, covers any illicit act which impairs the strict and faithful fulfillment of the obligation. Article 1173. The fault or negligence of the obligor consists in the omission of the diligence which is required by the nature of the obligation and corresponds with the circumstances of the persons, of the time, and of the place. Dolo causante. Those deceptions or misrepresentations of a serious character employed by one party and without which the other party would not have entered into the contract. Dolo incidente. Those which are not serious in character and without which the other party would still have entered into the contract. Some particular or accident of the obligation. Requisites for fraud to vitiate a contract. 1. It must have been employed by one contracting party upon the other. 2. It must have induced the other party to enter into the contract. 3. It must have been serious. And 4. It must have resulted in damage or injury to the party seeking annulment. Default or mora is the failure to perform an obligation on time. It signifies the idea of delay in the fulfillment of the obligation. Article 1169. Those obliged to deliver or to do something incur in delay from the time the obligee judicially or extrajudicially demands from them the fulfillment of their obligation. When is demand by the creditor not necessary in order that delay may exist? 1. When the obligation or the law expressly so declare, or When, from the nature and the circumstances of the obligation, it appears that the designation of the time when the thing is to be delivered or the service is to be rendered was a controlling motive for the establishment of the contract, or when the demand would be useless, as when the obligor has rendered it beyond his power to perform. Article 2209 solidifies the consequences of payment of interest as an indemnity for damages when the obligor incurs in delay. Article 2209. If the obligation consists in the payment of a sum of money and the debtor incurs in delay, the indemnity for damages, there being no stipulation to the contrary, shall be the payment of the interest agreed upon, and in the absence of stipulation, the legal interest, which is 6% per annum. The three kinds of default or mora. 1. Mora solvendi, or the delay of the obligor or debtor to perform his obligation. This delay is called mora solvendi ex re when the obligation is an obligation to give, or mora solvendi ex persona when the obligation is an obligation to do. 2. Mora accipendi, or the delay of the obligee or creditor to accept the delivery of the thing which is the object of the obligation. And 3. Compensatio mori, or the delay of the parties or obligor in reciprocal obligations. Fortuitous event and force majeure. A fortuitous event is an event which cannot be foreseen or which, though foreseen, is inevitable. Ordinarily, the terms fortuitous event and force majeure are used interchangeably. There is, however, a technical difference. Force majeure is a term that is applicable only to those fortuitous events which are dependent upon human intervention, such as wars, strikes, riots, etc., while fortuitous event is the general term that is applicable regardless of whether the event is independent of or dependent upon human intervention. The rule regarding fortuitous event. Article 1174. Except in cases expressly specified by law, or when it is otherwise declared by stipulation, or when the nature of the obligation requires the assumption of risk, no person shall be responsible for those events which could not be foreseen, or which, though foreseen, were inevitable. That's it for now, and thank you so much for watching. Bye!